SIDCO refuses the conversion.
No, I'm sorry.
Can I just show that to you, Vilas? Can I just show?
SIDCO has
Because
taken
it's like a
25
total
crores
collusion,
extra.
total collusion between SIDCO and the builder.
Right on.
So-
Now it is
No,
become a PIL.
No initiative. Want,
Yeah.
Vilas,
while we are not inclined to interfere, the petitioner
Can we
will be entitled to. That's all right.
Vilas, against this
Kindly
conversion.
Don't say anything, Lord. He
No,
starts
because
another
this is
round.
public exchequer at stake, Vilas.
Lord, he will start
This is
another round,
2007.
blackmailer will come.
I'm sorry, with 2007, it is.
Come like this. Mr. Rao.
So Lordship may leave it open to take my remedies.
On the one hand, you say that you are interested because you purchased the entirety of the share capital.
Yes, Vilas, correct.
That means that you are personally interested.
Not a
No, that's why I'm saying.
So now you don't get into the matter.
No, therefore, Vilas, I file an application saying, please stop them from creating commercial.
Confused, I think your clients, and we don't know.
Lord, the Lordship should not say anything. Lord,
Vilas,
the
what
facts
can I
of
do
this case, blackmailers
Withdraw.
will come again and again.
Withdraw.
With liberty to challenge the subsequent.
Permission to withdraw. Mr.
That's
We
all.
take all liberties available, Vilas.
Lord, kindly
for
move.
subsequent
Gaurav
development?
Agarwal seeks to withdraw the special leave petition, permission to avail other remedies. Permission granted, special leave petition dismissed.
If your lordship can specifically mention that 16(3) order can be challenged because there's subsequent development, your lordship. Please, your lordship.
You kept it open-ended.
Obliged. Grateful to you.
This has to be tagged with one SNP level.
A question is pending.
Plus, similar matter is pending before my lord. Notice.
Post it along.
Lord. Lord, delay is there is a delay, so
Notice.
obliged.
May please, your lordship.
Got the title, but.
It's a suit for declaration and injunction, your lordship. The petitioner herein is a defendant. It's very interesting to note. In fact, a suit for declaration is filed, but not for possession.
Cross objections.
Please, your lordship.
Notice.
My lord, status quo in the meanwhile, your lordship.
Yes.
Please, lordship.
My lords, in this case, we have challenged the confirmation of sale on the basis of the fact that, admitted fact that there.
Second action. We are against your third contest to the auction, is that?
My lords, My lords,
Petition by.
admittedly, Rule 64 has not been complied. So it's a order passed without jurisdiction, my lords. My lords, today it can't be allowed to stand.
Yeah, and I
Please, may hold.
Wait, 3 rounds.
Yes.
Third round.
My lords,
Yes.
in the first round, I was given a liberty to challenge and to come back to the court in case there's a valid ground. And this is a valid ground, my lords.
High Court has dismissed your petition previously, madam. How can you again challenge?
The High Court gave me a very specific liberty to come back to the court, my lords.
First is a suit which became final. Second is a writ.
Writ.
Anyway, it doesn't matter. You argue well, thank you.
My lords,
14,
my lords may see.
item.
Very grateful, my lords.
There's a letter.
Item 50.
Wait, please. Lords, I have vacated the property. To begin with, I wanted to tell your lordship this. Lord. Now, my lords, on the rent, there is one thing, Lord, which has been concurrently missed. Now, what has been missed is, Lord, that the agreement, whether it is of 1 lakh rent or 4 lakhs rent, Lords, is unregistered. Both are unregistered. Now, please just have the plaint with us. Please have, my lords, plaint, annexure P4, page 78. Now, is this believable story, para 6?
All concurrent, Mr.
Lords, one legal point I will not place for your lordship submission. If your lordship agrees, we have a case. Otherwise, we don't. But just please have para 6 because everything turns on this. Is this probable in a lord's property where the tenant is saying that lord 1 lakh is the rent and landlord is saying 4 lakhs?
4 lakhs.
Please have para 6 with me, lords. Page 81 bottom.
All concurrent.
Page 81 bottom. I'll quickly read it, lords. That's the plaint by them. That on demand for payment of monthly rent, D2345 threatened the plaintiff and her husband of dire consequences. One day in the night, the D2 and 4 came along with some unknown persons. By giving threat of dire consequences to the plaintiff and her husband, compelled them to sign in one stamp paper. Now, this is the agreement where the rent is 1 lakh.
Do you take that?
No, Lord, there is just, Lord, bear with me. Otherwise, I won't have troubled your lordship. I'll just quickly read this.
All facts, Mr.
No, Lord, there is something on law which they have
This
missed.
is law.
The law is that it's an unregistered agreement.
You are saying that it is 1 lakh. He's
Yes.
saying 4 lakhs.
Yes.
They led evidence. All evidence was considered all
Good.
through.
Now, my lord, the point
All
is,
evidence is also there. How many?
if it is an unregistered agreement,
Three-
just allow me to
Thrice
place.
over the courts have held.
No, my lord, but what they have missed is what I wanted to show. Please have para
You
6
didn't
minutes,
enter
then it
the
should be
witness
clear.
box.
Please allow me to.
You didn't enter the witness box, right?
Lord, assuming I didn't. Yes, I didn't.
Then-
Yes, I didn't.
then
But
what
assuming,
like-
assuming that is the position. assuming
That
is
adverse inference is also
One
against.
second. Thank you.
No, Lord, one thing.
Enough.
On the facts, your lordships may not hear me, but on law. Lord,
You
on
will-
law, there is something we have to say. Because on law, Lord, just give me 2 minutes.
Thank
Lord, on law, there is something to say. I won't otherwise not stick to it. Allow me to just say this. Lord, even the 4 lakh per month agreement is an unregistered agreement. Now, para 6 says it was torn to pieces and the person, Lords, then repaired it by putting cello tape and produced it in the court. We were saying that the rent agreement says 1 lakh per month. We even gave to the GST authorities. Now, be that as it may, please have Paul Rubber and Lords KB Saha. There is just one legal point we wish to submit, Lords. In an unregistered agreement, can Lords rent be calculated in the manner in which the agreement says? Because the tenancy is for 5 years. The tenancy is not for 11 months. Please have this judgment, Lords. Please have Lords Paul Rubber, because your lordships have said that in an unregistered agreement, it cannot be Lords admitted in evidence. Section 17 and 49 of the Registration Act. And no term of that agreement can be read into evidence except for collateral purpose. And any purpose mentioned in the agreement is not a collateral purpose. These are the 3 principles laid down, Lords, in Paul Rubber. Please have page 1 of this compilation. Lord, I am a tenant who vacated, whom Lord punctually paid 1 lakh. I will show from the cross-examination. I was paying 1 lakh after the agreement and there was no objection by them. Suddenly after COVID, they file a suit to say that the rent was 1 lakh.
Page.
Yes, Lords. Lordships have this Paul Rubber. Lordships will have Lords page number. Lordships have page 16, para 19. Bottom of page 16. 16, the Lords, the pagination which we have put. Bottom of page 16, Lord. The expression collateral purpose has been employed in the proviso to section 49 to imply that content of such a document can be used for purpose other than for which it has been executed or entered into by the parties or for a purpose remote to the main transaction. This view was taken by this court in an earlier decision in KB Saha. The position of law. Now these KB Saha I am reading, Lords, para 34. From the principles laid down in various decisions of the court and the High Court as referred to herein above, it is evident. A document required to be registered if unregistered is not admissible into evidence under 49. Such unregistered document can, however, be used as an evidence of collateral purpose as provided in the proviso to 49. A collateral transaction must be independent of or divisible from the transaction to effect which the law required registration. A collateral transaction must be a transaction not itself required to be effected by a registered document. That is, if a transaction creating, etc., any right, title, or interest in immovable property of the value of 100 rupees. If a document is inadmissible for want of registration, none of its terms can be admitted in evidence, and that to use a document for the purpose of proving an important clause would not be using it as a collateral purpose. Now, Lords, they were saying 4 lakhs. I was saying 1 lakh. Just please have the cross-examination of Lords the landlord.
You have, instead of that, both of you adduce oral and documentary evidence completely, and you have brought home a finding
Yes,
by the courts that what was really agreed upon is 4 lakhs. Is the
No, 1 lakh.
fine.
1 lakh, my Lords.
What was agreed upon is what the findings that have been done. And even in the High Court, as you see, the entire thing you have argued is about the evidence of PW1, PW1s and so on.
Because,
Exactly what was considered. Court saying that.
no, page 121.
even
I'm grateful.
High Court.
High Court, yes, my Lord. So therefore, PW1, what PW1 says,
considered all
page
that.
121. Just 1 line at page 121.
Remains a fact only, Mr.
No, my Lords, if it is not
All right.
registered, you can't treat it as 4 lakhs. Just please have 121
All right.
2 lines. If your lordships would not agree, we
Now
will
you're
treat it
leaving
as.
now. I thank
Lord,
you.
page 121 for a minute only.
Dismiss.
As your lordship.
Enough.
Lord, we'll leave you over.
May it please your lordships. My lords, a consideration of 1 crore 50 lakhs, my lords, paid entirely in cash, my lords. And that is believed by the High Court without any evidence. My lords, I have a question of law, my lords. 269 SS of the Income Tax Act, my lords. You cannot have a transaction which is in cash beyond
Kapadia.
Admit.
Task you have. Task you have.
My lords, absolutely not, my lords. May I just say, as far as this issue, my lords, the fifth of considering, my lords, section 20 is a discretionary relief, where my lords will not come to aid an illegal transaction. Here is a trans.
No, but you have one query. You have admitted your signature on the agreement. Receipts exhibit P2 to P4 have been proved.
No, my,
And
on-
all courts have exercised the discretion to decree the suit for a specific performance of contract.
my lords, that's why
So
I
the-
started with the question of law, because evidence, I will argue.
So
that
the only thing is that it contravenes the provisions of
Lords,
Income Tax Act.
Two legal points. One is to, my lords have
Where is this
these
land?
three judgments, my lords.
Where is this land?
It's in Faridabad. And what does the trial court say, my lords? If it was fraud, you would have filed a criminal complaint. That is, and they really don't go into the evidence. In the evidence,
All these. Three kuntas, is it? Kuntals, five margas.
yes, my lords. It's
Agricultural.
about 3 acres, my lords.
Not income tax. We have, don't be cut off from the realities of life.
That's right. I can understand, my lords, show something. I can understand some portion of it is
Agriculture is
is-
normally dealing.
counted. This, my lords, 1,50,00,000 lakhs and not a penny. All of it in cash, my lords.
Well, between your transaction,
My-
don't express surprise.
On the legal point.
Don't
say,
express surprise and it doesn't shock anybody.
My lords, it does shock me, my lords. At least there are three judgments where my
You are
lords,
cut off from the realities.
my lords will just see this. My lords will see these three judgments. My lords will see. This is
What do you want us to see?
my lords. First, my lords, this is a Supreme Court judgment. Para 10 of that, my lords, where the court specifically says, Para 10, my lords. If Para 10, if there are unaccounted transactions, then they are illegal transactions. No court can come to the aid of the party in an illegal transaction. It is settled law that in such laws we allowed a lie where it fails. Now, my lords, another one specifically, one more, my lords. May I show this is a Delhi High Court judgment, but specifically on what I am trying to urge. Justice Naveen Chawla's judgment, my lords, in Amanpreet Kohli. Again, this was with respect to an amount that was paid in cash. And as a postscript, my lords, you'll see para.
These are all real estate construction.
My lord.
This is a specific performance
Therefore, it is required.
relating.
Section 20, my lords, is a discretionary remedy where I can understand in practical reality, some portion is in cash, my lords will possibly overlook. But in a transaction like this, when an amount of 1,50,00,000 lakhs, my lords, is paid in cash, my lords did not come to the.
These are not at one spurt. 20th of January, he paid 50 lakhs. They're on agricultural land. And then 22nd of January, he paid another 50 lakhs. And then 23rd January, he paid third amount. And then he has entered into an agreement. In that agreement signed by all of you,
No.
that this amount, that amount is recovered.
See, we had taken a loan of 5 lakhs. He had said, look, these signed documents, blank signed documents were taken by us. 2 of them were returned. 2 of them returned, 1 was not returned. On that, these changes is what we are saying, completely forged and fabricated. And with respect to the amount of 1,50,00,000, absolutely no evidence produced as to their bank statements show there are literally no amount, my lords, in the evidence of
Receipts have been proved by the witness.
72. What does he say? He says he collected this amount. My lords will say, in the evidence of responding one, my lords, what does he say? He says he collected this large amount of 1,450 lakhs from various individuals. My lords will see that. Absolutely no source of funds. And on the day that the agreement was to be executed, the amount was not there in his account at all. My lords will kindly see that he was absolutely, he has has absolutely produced no evidence with respect to the amount that he has supposedly paid. No bank transaction at all, my lords. The income tax returns were called for by the High Court was not produced. In the
17.
Thank
you. 17th
agreement.
Item 17.
One more legal point. my lords. This is also an unstamped document, my lord. 10 rupees stamp paper. It should have at the first instance before the trial court. This should have been impounded.
Thank you.
My lord, since on that also I have one.
Item 18.
With agreement.
17.
Petition.
17 who is in?
Right. Right.
17? Yes, sir.
Lord, there is a statutory vacuum in the Advocates Welfare Fund Act. Just have a look at the act. There is a reference to Wakalatnama in Supreme Court, but the money will go to the Delhi Bar Council. Now, please see the advocates defined in the Advocate Welfare Fund Act, Lord, that your lordship will find at page.
Advocates Welfare Fund is, you're talking about 27.
Yes. Now, please see, advocate means an advocate whose name has been entered in the state roll prepared and maintained by a state bar council under section 17 and who is a member of a state bar association or a state. So really SCB is completely out and our members, many of them retain their roles in various roles. So what we have suggested, Lord, because there is a issue with regard to getting into this act. The issue is that if I get into this act, if your lordship will see section 16, the Supreme Court bar has to get recognition by the Bar Council, Delhi State Bar Council. We can't.
It doesn't have a standing on its own.
Absolutely. So it has to come in the Supreme Court rules. Lord.
And also Supreme Court Rule 15A, something can be.
We can, yeah, we can. We have already suggested.
Perhaps through because it's definitely a need of the hour.
And Lord, we have to, every time something happens, Lord, we have to depend on people funding for everybody. That is something, Lord.
And what the need is actually, those who it is perception that Supreme Court means.
The affluent doesn't mean that.
The real mainstay.
Your lordships have been in this bar.
The real mainstay is.
We are only talking of people who are really whose courts they are all getting white by the the sweat that happens and they are in these buses. Only short date and I'll serve dusty. Returnable in suggesting.
Senior, that on the lordship is examining the
Rule positions also.
So this can go there.
needed.
The other thing, Lord, there is a small correction. I'll just give me liberty to make some correction. There is some typing mistakes. One, we said 500 and the priority is only 100. So I'll just
issue notice.
Returnable in 2 weeks, Lord. I'll serve everybody dusty. And small correction.
Sheet on record is permitted to carry out the.
Very deeply obliged.
Errors in the order.
Deeply obliged.
Writ petition. Item?
18.
950.
So they don't have a.
But for the petitioner, my lords, the High Court refused to condone the delay in filing the second appeal.
50 days delay.
But, the reason is that's only aspect. That's only aspect I'm here before my lordship is from 1990.
2.5 years delay, sir.
Yes, sir. But only aspect. But I can understand what's happening, Lord. But from 1993, my lords, they have been conducting the litigation. In the earlier round, they have succeeded. Then 2007. Now this
Habit. Even here you have come with
48 days delay, my lord, because I filed a review application. But review application was there, my lord. But only consider this. But it's a suit for declaration recovery of possession. But what my client is in possession is around 1,250 square feet of land. But the declaration is for 13 cents. But from 1993,
Thank you.
19, I'm requesting for a passover.
Asua.
Item 20.
It's an adjournment order. 20, na? 20, na?
I said 19.
19?
We could have,
Asua. Asua.
it was a case notice site.
That's what we come against me.
Ah,
The 19th council is here.
ah,
Yes,
An
Your
issue notice.
Grateful, Your Lord.
20th.
ये तो अपील ये तो इंफ्रक्शंस हो गया होगा appeals have been
This is infectious because appeal is withdrawn. They dismissed. Next. Item 20 is against an adjournment order and later on it's withdrawn. This right discuss. Also, 21?
There is a letter in this.
Yes.
Deep down.
Item 22.
Why the provisions of Order 11, Rule 14 and 11, 12 and 2, issues were framed in November 2022. The application for, my lord, summoning and admission and denial is moved in 2024. And, my lord, the locus standi is that he's filed a suit for declaration, not disclosing that he has already been removed in 17.
production of document
Action of document.
No, my lord, it is not permissible.
Interfere.
Issues are framed under Order 14, Rule 2, my lord, in 19th November 2022.
What we are saying is that it's
Sorry,
not a case for us to interfere in this. It's not a case for us to just additional documents.
So it's a roving inquiry, my lord. What he could not achieve in those applications, my lord, the High Court has permitted it without going with going. My lord, my score in this court has been always on duck, my lord. I have
Really?
Yes, my lord. Every time I have been on a duck, my lord, bowled out on a duck. Every time, my lord.
That will not matter to a council.
Lordship may grant me liberty, my lord, that.
What liberty you
My
want?
lord, it's a roving inquiry. It's a roving inquiry, my lord. If this kind of is,
challenge that order
if
in
this
appeal.
kind of, my lord,
Case decrease.
In any event, this interim orders permitting additional document
my lord,
will all be
he
subject
has
to
to stand
final
on
order.
his own legs, my lord. He is not to go on my record, my
I
lord, is
understand
it's a
that.
privileged document. Can he summon my privileged document, my lord? Answer is no. Lord, 1998 Supreme Court 2835 says you have to stand on your leg even you have a debt.
Privileged document.
Sorry, Lord.
It's not privileged document.
Privilege, my bank accounts, not personal bank accounts. How can he be summoned under DERA's documents?
It is not really a bank.
Yes, my lord, it's my privileged document, my
These
lord.
are, we'll tell you what.
May I explain, my lord, what happened?
20th of March 2002 is the resolution which is only in your possession.
We are admitting. I am not on that, my lord. Resolution is not. I am only worried about the document number 4 in the list of witnesses, my lord. He is asking, my lord, what can we see?
Mr. Umapati,
My lord,
what is your
come
item
to
number, sir?
174.
Whose account is that?
What
Page
is your item
174.
number?
24.
Okay.
Suit would not be maintainable in view of because this order has been upheld, my lord.
What is that?
170, my lord.
One?
Not in an order, in an application under order
One?
170, my lord, 170. In an application under order 39, rule 1 and 2 filed along with the suit, my lord, the trial court gives the finding, 4th line from top, my lord. I know that. I know.
Yes.
Lordship has been able to locate it, my lord. The
What?
plaintiff, 4th line from top, my lord. The plaintiff has been removed from the post of the assistant by document D18 on 15th November 17. Plaintiff has himself admitted the said fact in a statement given before the police in an inquiry, the copy of which has been placed on record D90. The said termination was never challenged by the plaintiff despite he has no locus standi, my lord, and no prima facie
You are
case.
saying, you are telling us about bank accounts? Where is that?
Lord, no, yes, bank accounts, my lord. That, lordship may kindly see the application for summoning, my lord.
Therefore,
This is at page P 21204, item number 4. 205. Concerned bank official, clerk of, sorry, my lord, I'm sorry.
5th August 25.
No, my lord, P21, my lord.
20.
P21 is an application for summoning at my back, not this is
5th of August
recalled.
25.
This order has been recalled, my lord. This application was allowed, it has been recalled, which was now has been allowed by the High Court without noticing the fact that what he could not achieve.
See, ultimately, there are 3 documents, right, which will fall for consideration.
Fourth is the one I am aggrieved of, Lord.
What is that fourth one?
Lord, the concerned
They
bank
have
of
not been mentioned so far as the
page 205.
minute. You look at the application, 15th January 24.
15 January 24 is, my lord, he is dismissed by the trial court.
That is where it all arises. Huh?
Yes, my lord. It has been dismissed, my lord. Now goes into a roving inquiry. It is his, my lord, case. He has to prove, discharge the burden under section 101 of the Indian Evidence Act. As per 1998 Supreme Court 2835, Lord, even if I have no defense, he has to stand on his
Whole
own
thing
legs.
arises out of this very application.
Sorry, Lordships.
The documents that he is asking arises out of this very
Lord, what he could not achieve in those applications, now the court has allowed this application, which I am grieved, my lord,
Towards that
P21.
application?
P21, Lord. I am totally aggrieved of, Lord. Page 205, P21. Dated 12th of August 2025. He moves an application, my lord. 10 opportunities given to him, my lord, to lead evidence. He does not do it because he doesn't have any document to prove. He has to stand on his own leg, my lord. He has come to the court. I have not come to the court.
Which is the document you're
Lord,
saying? Some
page,
bank account,
page 205, P21, fourth document.
Concerned
Serial number 4, my lord.
Okay, this bank account was.
Yes, my lord. My lord, anybody can come and
Tell us, this account is held in whose name?
It is in the Dera's name, Lord.
It's the Dera's name.
Yes, and secondly, my lord,
Individual.
already this litigation has been put to rest by this court P2, my lord. Already somebody had filed the suit and this court had intervened. P2,
Dispute is about data.
P2, my lord.
Dera only, it's not an individual.
Yes, Lordship, may kindly see P2, my lord.
Dera only, it's not your individuals. It's the whole dispute is about.
Lord,
Dera.
he's removed. He's removed in 17, my lord.
Different matter.
Lord, if I am removed, can I, my lord, argue as...
Between two parties.
My lord, if I am removed, can I, my lord, institute a suit? I have no locus standi.
Therefore, it is not relatable to personal account. It is the Dera's
My lord,
account.
he has no locus standi. With all humility, my lord. He's been removed in 2017. With all humility, my lord.
He did.
And his interim prayer has been rejected.
Okay. Thank you.
Again,
Next time.
Again, I am bold down and duck, my lord.
Next time.
Thank you.
23.
My lord, in this matter, in 2017, suit was filed by the respondent. There is no reference to the additional document which is sought to be filed now. Written statement was filed. Replication against silent 2019 amended. 2022 issues were framed. Evidence affidavit was filed. Then those documents were filed. And High Court committed an error by recording that these documents were filed along with the replication. They were not filed along with. But look, along with the documents, he's now trying to introduce two
Each
bills.
document people are coming in as
My lord may have page 228 and 230. My lord may have page 228 and 30.
Not a case, sir. Thank you.
My lord, he's now trying to introduce a will, and without the pleading, I will be in difficulty to lead
Not
the
a case,
rebuttal
sir.
evidence.
Thank you.
Please.
May I please your lordship. Lordship, this is an appeal under the Electricity Act, my lord, and reversal of findings. Lordship, may kindly see paragraph 40 of the impugned judgment, my lord, page 28. Lordship, middle of that paragraph, we are, however, of the view that had the State Commission allowed the open access to the appellant by its earlier order dated 15/9 on the similar conditions which were proposed by the appellant at that stage and which has been agreed and imposed by the impugned order, LTA would have been granted for the third party sale. My lord, in the present case, my lord, the matter travelled twice, my lord, before the APTEL remanded it. And while in remand, my lord, the generator did not even ask for the decision on the merits of the rejection of LTOA. My lord, LTOA was rejected in 2016 by the Madhya Pradesh Power Transmission Company, which was a subject matter of challenge, my lord.
They didn't grant it. It is really unjust enrichment, Mr. Umapati.
No, Lordship, the fact is, my lord, he himself, Lordship, may kindly see one more thing, my lord.
Right.
If you, Lordship, just see above that paragraph, in the beginning of paragraph 40, my lord, the second sentence.
This is a very.
I read that entire paragraph for the context, my lord. Thus, in view of the above deliberations, we are of the view that appellant is entitled to receive compensation for the loss it has accrued
due to denial. Now, next sentence is important, my lord. It is also acknowledged that the appellant agreed for the condition imposed for injection of power free of cost in terms of the letter dated till grant of open access. Now, this non-grant of open access was subject matter of a challenge before MPRC. MPRC rejected his case. Matter came to APTEL. APTEL remanded it, my lord. Second round, he forfeited that prayer for the decision on NTOA. He only focused on the compensation to be paid, and MPRC rightly rejected the compensation. But my lord, here, and one more fact is, my lord, I am a distribution company. I am no
So,
role to play.
Umapati,
Yes, my lord.
sometimes when you are on VC, no,
Yes, my lord.
just lift your head and also keep looking. That
Okay,
judge
my lord. Sorry, my lord. Sorry.
not speaking. Huh?
Yes, sorry, my lord.
Not sorry. What we're saying is that they
Yes,
came
yes.
midway. The commission came midway. They didn't grant it from the time they were injecting power into the grid.
Yes.
Granted it not from 2016.
Yes, they have granted the
15/9/2017. There's
Yes,
no
my lord.
denial of the fact that you took the power. There's no denial of the fact that you used the power. So it will be unjust enrichment. Just because their application came to be accepted at a later point of time, you can't say earlier power you gave to us is all quits and we will not pay you anything. So therefore, they reached a reasonable limit of reducing from the original period that they have supplied power to you, but confined it only from a later period of 15th of September. And also 15th September to 10th of May.
18.
Short period.
Yes, my lord.
Why should you
But
be contesting a matter like
No,
this?
no. Your
Commission-
lordship, only one more
Unjust
fact, my lord. One
enrichment.
more fact.
Imagine you are
My lord,
positioned
I am not
for a
my lord,
generator.
the only my lord, only other point is, my lord, I am not responsible for grant or rejection of the LTO. I am the distribution company.
You are not
But
saying
this
that.
liability is
You are
fastened
not
on me.
saying
That is
that.
one.
What you are responsible is that you took the power and used it. All right, then you will be bound to pay it. You can't have
But my
unjust.
lord, in this case, having
Are
the
you convinced or not?
generator agreed to pay supply the power free of cost. That is also recorded in this order itself, my lord, say very same page.
Say we are of the
He
opinion.
has offered to
Has not
till the
committed
grant of LTOA. LTOA is not granted.
our law in passing the order impugned before us. Having heard Mr. Umapati, the senior counsel, on behalf of the petitioner, there was the opinion that there is no merit in this appeal. Appeal is dismissed. Thank you, Umapati.
Then oblige.
But in execution, we had raised a preliminary objection with respect to territorial jurisdiction that the property, my lord, is not situated within the territorial limits of the court, my lord, the executing court, which is the commercial court here.
What happened? You are
I'm the judgment debtor, my lord, in that
You are the
sense.
judgment debtor.
And my lord, there was a direction, my lord, to
Oh, in the
disclose our
ED.
assets.
What happens to the 34?
34 has been, my lord,
Dismissed.
rejected, my lord.
No 37.
37 is pending.
37 is pending.
Sorry. Correct. 34 is dismissed, my lord, also on the ground of lack of territorial jurisdiction. But be that as it may, my lord, insofar as present execution proceedings are concerned, application was filed, my lord, directing us to disclose our assets. We disclosed our, my lord, immovable assets, my lord. Then the court issued a direction.
The Delhi property.
So the bank account in Delhi. So the
Previous
bank
matter
account
was
in
also
Delhi.
like that.
I'm sorry.
Previous matter was also exactly that.
So bank account is in Delhi.
You don't have any. Who are you? OIO.
I'm OIO. So the court says this very
amount. What amount?
My lord, 2.4 crores. Now the court says, my lord, they rely upon order 21 rule 46. Please have a look at order 21 rule 46 for a minute. Page 51. Page 51. Just because the bank has a registered office, my lord, my account is in Delhi. It says bank has a registered office there, my lord. Just have a...
About the Para 7
territorial
of the order.
jurisdiction.
Sorry, my lord.
Para 7 of the order.
Yeah, let me read, my lord. Then I'll come back to 21, para 7. Yes, my lord. May I read that, my lord? Oh, this is correct, my lord. The registered office of Axis Bank. My lord. The garnishee, so-called garnishee, my lord. Their office is, my lord, there. The question is, my lord, order 21.
Will you pay the amount anyway?
Sorry, my lord.
You tell us how will you satisfy the...
No, I deposited 50%, my lord.
Where have
Oh, 96% has been deposited.
where?
Civil court is Ahmedabad.
Ahmedabad. In the executing court, we deposit 96%, my lord, because of the direction, my lord.
So this is EP, is it? 36?
Execution. We are in execution proceedings, my lord. 37 is pending. These are arising out of execution proceeding where we raised this objection.
They attached your bank accounts in Delhi.
That's right. That's right. This is what happened. We said
How
you
much
can't do
more
it.
is there? All right. How much more is there? How do we give an alternative instead of that? What's the other alternative you can give?
The decree had to be transferred. Your lordship knows.
No. What is the alternative security that you can give?
No, I have deposited 96% of the amount. I've already deposited because there's a direction.
Notice stay.
Very well. My lord,
We will
your lordship
transfer-
says the money is lying in court. Let it remain in court, my lord. It's lying in court. We have deposited the money.
Okay. All right.
Yes.
Just issue notice. That's all.
No.
Issue notice. Pending disposal of special petition, the amount deposited shall not be withdrawn.
Lordship, please. Grateful.
We are only troubled because of this repeated thing happening.
Yes, my lord.
Filing petitions outside the jurisdiction.
Correct.
Attaching.
May I please, my lords? My lords, I'm in a
Wait.
May I please, my lords?
The adjournment order is.
My lords, item 26, my lords. My lords, I'm in a real predicament, and I'll tell you what my predicament is, my lords. My margin is only not the amount that they are charging me as an excess GST. Various, my lords, advanced ruling centers have held that this is a railway product because this is an air conditioning for a railway carriage.
12th of January, what happened? 12th January.
Let's adjournment after adjournment, the other side is claiming. Now, I'm not asking for an interim. I'm asking something much lesser. I'm saying I'm right or wrong. It's a 5-minute matter. On the next date, please hear me and give me a decision, my lords. Or my business will run out.
What is the
The
next
margin
date?
is only not 10.
What is the
18th May. 18th May is my next date. Just, my lords, once and for all, hear me and tell me whether I'm right or wrong.
Bhandari, people who have money come here. There are hundreds and thousands.
I
As a
totally-
lawyer, don't you know? Hundreds and thousands of cases like this. So it doesn't benefit the client. It disrupts the system.
I know, but my lords, tell you what my
But then
predicament.
nobody cares.
I have no interim in my favor.
No,
I am so high and dry, my lords. They keep on taking adjournments after
Bhandari,
adjournments.
are you unaware of the fact?
Sorry?
Are you unaware of the fact that High Court is so much
But I'm
burdened?
totally
Then-
aware. You're right, my lords. But
Then
why I come, my
then-
lords? Please see why I come. I'll tell you, my lords. Just give me 2 seconds.
which client, given an opportunity, will not come?
I agree.
Only when he has money, he'll.
That's why, my lords, on the.
So it benefits everyone.
I agree, my lord. At the outset, I said, my lords, I'm not
philosophy
asking for
in
an
this.
interim. My lords, may just,
Philosophy in this
my lords, may
is
just
not-
direct them, my lords, on the next day, they should at least try and hear me on the merits, my lords.
All right. We are informed by Mr. Bhandari, Leonard, Senior Counsel, appearing on behalf of the petitioner that the case is now listed for hearing on so and so. We hope and trust that the High Court will take up and dispose of the matter.
I'm so grateful. 18th May, my lords, the date.
Yes.
I'm so grateful.
Item 27.
Order framing an additional issue of.
Please, my lord, I am for the petitioner in this matter.
We should impose costs.
Yeah.
No, my lord may see,
Sir.
the lordship may see my application, which has been I proposed for an additional issue, but the court, the trial court has framed.
Framed or not, you will come in an SLP means what?
My lord,
They broadly framed also. Hardly a case dismissed. 27, 28.
For 5 issues arise, your lords. First, I am a shareholder of a company. It started as a joint venture, then it concretized into a company. Now I am held liable as a shareholder. I am sued also as a shareholder. My lords, at page 59 in the replication, they say, further assuming but not admitting that the defendant number 1 company is
36 lakhs plus undertaking, right?
My lords, and I am supposed
Of
to give an
1.2
undertaking and close my further right of appeal, my lords. I am a shareholder, and that money decree sought to be made against me as a shareholder
and to be executed against me as a shareholder, my lords. That's the first part, and it was all done under the period of moratorium, and the company has been liquidated. All throughout when the moratorium was going on, this civil suit continued. And I am merely a shareholder. There's no privity of contract. And the second part of the joint venture is released saying that he has no at all concern with the company, my lords, at 67, because it's a new company.
Been liquidated, but liability will be taken by the.
My lords, we were two companies which formed a joint venture. The joint venture gave them the orders. They were supposed to supply to the joint venture, which is a separate company, which is a third company, and I merely become a shareholder there along with other shareholders. The second important shareholder there at page 67, it is not made a company. They file an application for impediment. My lords, please see that order at page 67. It says, since it's a separate company, nor it was involved in the transaction between the parties either directly or indirectly. I am also not involved either directly or indirectly as a company. So I am on the same footing, and this order is passed in the same suit. It will act as res judicata.
Notice.
My lords, my lords, now the date has been fixed for me to pay at 31st of March. So my lords, if stay could be granted. Much obliged.
Similar matter.
My lord, FIR, I'm praying no coercive action since this writ is
Grant you.
obliged.
Item 30.
Please.
My lords, we have filed a report, my lords, because when your lordships issued notice, your lordships noted that there's a lot of delay and a senior officer should hold an inquiry.
We'll issue notice.
No, my lords, we also want to withdraw our SLPs.
Why you want to?
My lords, we want to withdraw for the reason that the High Court has only said that we were wrong in not granting them hearing. So for demolition notices, my lords, before issuing those, we should have given them a hearing. So your lordships will permit us to withdraw and comply with the High Court judgment. My lords, we should not.
At whose instance all this is happening?
We should have never filed these SLPs. Otherwise, our own section mandates that opportunity of hearing has to be given. The DDA Act.
Wisdom.
Yes, my lords, I am sorry. Only after the whole inquiry has taken
Wisdom.
place, the senior officers have.
Who is powerful? Who is more powerful? Who are? Why did the High Court pursue this matter from 2015?
Yes, my lords.
From 2015, government land, forest land occupied, asked them pursued from time to time. You saw that?
Yes, my lords.
2014 onwards.
My lords, we want to
High Court
expedite
is
the whole
pursuing, you are saying, and today, rich and powerful are in possession.
My lords may record my
Ah.
statement that we will take expeditious steps in terms of the High Court judgment.
Why?
Because we have to give them opportunity of hearing and then take action, my lords.
Okay. We'll keep this pending.
Lordships
Give
may
an
record my statement, permit us to do that exercise and come back.
You take action and come back.
Please, my lords.
Milords, at some point, I might be, Milords, I should not step in, but there's something I must tell you. And Milords, this is not rich and powerful sitting in the land. There is a very telling story here, and I must bring this to the knowledge of the court, Milords. This land was given to some settlers.
No,
who
but what's the
migrated to
point? What's the point? What is the point in the High Court entertaining the petition in 2014 on the ground that these are forest lands which are occupied, and from 2015 orders are passed?
No, I'm sorry.
And
Milords.
committees after committees appointed.
This is not forest land.
Wall was to be built. We are not asking you at all. Wall was to be built. We thought wall, then they said wall is not to be built unnecessarily, but a fence, if it is built, that will be enough. That order is passed in 2017. And then again committee is appointed. Then again your affidavit says that yet again in 2021, illegal sales have occurred in 7th of October and 21st of December 21. And then again you issue demolition notices.
So, my lords, we
And
do want to
now you
pursue
say,
this is falling in the Mairoli Archaeological Park, my lords. But we'll take steps. Your lordships will record my statement, permit us to take the steps and come back, my lord.
well, you
Can I
take your steps.
Please, my lord.
We'll just adjourn this matter.
Milords, can I?
Your lordships may have to, my lords, because today we have challenged that finding of High Court. So your lordships will record my statement, permit us to proceed,
Yes, yes.
and then, my lords, your lordships may
My lords, this matter had
file a report.
Party Learned Additional Solicitor General states that action will be taken for removal of the encroachments after giving due opportunity after as per the directions of the High Court.
My lords, there is an issue.
This you have.
My lords, can I say something? My lords, I'm in a different footing. My land is not forest land. I'm nothing to do with that.
We are not saying anything.
No.
You find that you are
prejudice because this matter, we came on SLP to your lordships. Your lordships in this, against this impugned order, passed an order. Supreme Court, my lords, can I just show that order, my lords?
They are wanting to withdraw in that.
What they have done is something.
What do you want us to do?
No, my lords, my lords, please dismiss their SLP. I'll tell you why, my lords. Your lordships have passed an order against this impugned order. Can I show that order, my lords? Please, my lords, I have something to say. This land, which my land, that I am concerned, my lords, please hear me for 1 minute.
See a lot of drama in this.
My lords, there's no, my lords, I must dispel this. My lords, I must dispel this. There's a real serious issue. I must bring this to your notice. Then your lordships may pass whatever order you feel.
High Court says that no action can be taken without giving notice.
And
the government is now saying we will of course give notice. So therefore you don't want notice to be given with.
There's one more aspect to it. One more aspect to it, which the High Court says, my lords, and I must bring to your notice. First, please, my lords, this land was given to my ancestors when they migrated from Pakistan by the president of
Tell
India.
us all that. You are not
Lords, and my house is there for last decades.
Not necessary. We are not saying anything. We are permitting them to withdraw.
Let's just have the order, my lords. We've been relegated.
Solid. What did you write?
Please have that.
In view of this statement, in view of the statement made by the Learned Additional Solicitor General, you want us to keep it or postpone it?
My lords, we have an application for withdrawal, but the reasoning is this only. If your lordships want to monitor it, we'll do that exercise and come back, my
No
lord.
further orders are required, especially petition is disposed of in terms of application number. So,
Please, my lords.
very all right.
Grateful, man.
There are lots of
Yes, my lords, the batch of 11 petitions.
That's why I wanted to bring.
It's a common impugned order.
No, all of them are by you.
Yes, my lords, by us.
Then it's okay.
Please.
There's no difference.
Lords, the issue here was that people who've been living for decades, they suddenly demarcated without giving any hearing, any notice.
All right, now they will give you.
That was relegated to civil court by your lordship's own order.
Now they will give you, if at all.
Very well.
If at all, as per the High Court,
We had to challenge their demarcation report in a civil court, which we have done, my lords, pursuant to your own orders, this court's order. Your lordships passed an order giving me the liberty.
That demarcation report has not been interfered in, but I saw a lot more in this matter than I.
We filed a suit, my lords.
all right, you need it.
In fact, say that we are reiterating the observations of the High Court. Then not the order, but your lordship virtually upheld the order, because there can't be now a second round.
I'm grateful, my lords.
Right.
Yeah, Lord. The last hearing, I sought some time to produce additional documents, but I could not procure those from the local council. My lordship, I'm showing from the records what I have filed. Lordship, my grievance on 2 counts. First is with regard to demand. There's an allegation that the short depiction of value in the service tax return.
Remand order, right?
Sorry.
That's the remand order. Remand order.
No, there are multiple
There
demands.
are 3 things. One is the so far as the credit is concerned and export benefit, and third is upholding of the service tax demand of 1 crore.
Yes. Remand, of course, I'm not challenging. The challenge is with regard to the demand made, saying that I have shown depicted short amount in the service tax return.
What
compared to
this is just a reconsideration.
My
They have
lordship,
not decided against you.
This portion, if I may show para 4.13 at page 35. The appellant have contested this demand, stating that they have, along with the appeal file, annexure so-and-so detailed reconciliation chart, along with the nature of income duly supported by the chartered accountant certificate. Next sentence, in absence of such document to explain the difference, this is on record. I'm giving a chart. These documents were placed on record. These have been ignored. So this also fit case for the remand, and especially because of the reason, one of the component, your lordship,
You want other thing also to be remanded?
there are two aspects, your lordship. Only this demand, which is approximately 1 crore 10 lakhs. The second aspect, second demand is 61,000. This is demand due to the sponsorship fee, which I'm saying this is not a sponsorship fee, your lordship. This is a financial aid, so it's exempted.
And this is a service tax, right?
This is a service tax.
Service tax part of it, I think that's quite correctly. I think that need not be remanded. So far as those two other things are concerned, that remand is correct.
No, this remand,
right.
My lordship, the says that what it does, it says that I have not given the reasoning. There's no document, but the document is on record. I can file with the appeal also. I can produce a chart showing I've given the CA certificate showing the difference amount. Why there's a difference? Because those are exempted services.
Can you not bring the
Yeah, post dismissed. Next.
My lordship, this aspect has not been remanded, your lordship.
That's what we are saying, that this has not been remanded. I think to this extent it is correct. The earlier two heads on which the remand has taken place is very correctly, validly done.
That's correct. If
But
that
this,
is
I
been
think,
remanded, your lordship, this portion also has to be remanded because of the
is
reason.
unconnected to that. This is a service tax component.
My lordship, the service tax component includes the legal services and some export services that is arising out of export of services. Certain foreign
export services and
so
export credit.
Yeah, absolutely, lordship. The benefit of as export service has been remanded, but that component also forms part of para 4.13. So there's no remand on this.
All right, I think leave it at that. Thank you. Next.
My lordship, this.
32.
Laws in
Similar matters are pending?
I'm sorry, Milos.
Are there any identical cases which are pending?
No, Milos, there are no identical cases pending.
It's a parity matter.
Milos, the issue is of Secretariat pay. Now, Secretariat pay in the state was given before. Pleadings are complete, Milos. Yeah, Lordships may have it on a Tuesday then.
Lordship, before your Lordship here, there is a matter question of delay, your Lordship. There is 133 days delay.
How many days?
330 days.
336 days delay.
And your Lordship.
Parity, right?
Lordship?
Secretarial staff with
No, Milos, the University. Milos, I will address your Lordship then, Milos, but the.
Is there, how are they different? What do you say about the delay? They are objecting to the delay.
Milos, in the first matter or which matter are you talking about?
Both, but delays in both the matters.
So, Milos, the delay was on account of the review.
Also, there is a delay.
Milos, on account of the review, there was a delay.
No review.
Once. What is
It's
it
not-
of the review order?
Is it all attributable? In the first one, you didn't file a review.
Lordship, earlier also this matter.
Only in the later one you have issued.
And it's in the first matter.
Lordship.
Next.
Yes.
We'll
I'm
give you
sorry,
a date. We'll hear you. We'll
Lordships
hear
are
you
keeping it on Tuesday?
We'll fix a date. And then
Yes, plus. Very grateful.
Lordship are not considering the delay.
No, we are not condoning.
On that day, we
We'll see. We'll see.
Grateful.
They have a lot of explanation to give. Why it is not?
They have.
Why it is not parity on the merits of the matter?
From their own letter, the secretary has and member said, go immediately.
Milos, their case is that we got a contrary opinion initially, but Milos, it's in teeth of the clause. Yes.
What is 33? ये भी हमने
Lord, I appear in petitioner in item 33. Lord, the arguing counsel has fallen unwell, and hence I'm requesting a short accommodation in this matter.
Counter you want to file?
Well, we can argue it on the basis of this, but we can file it also.
Post for disposal. Post for disposal. Actually, it's not on that one.
Item 34.
No scope to release of the mortgage in that matter. Item?
I'm for respondent, Lordship. The
Before.
letter circulated in this matter. We may not receive, we may not.
As per the letter.
Item 35.
Item 35, may I request if it could be taken up next week, because I'm being led by learned Solicitor General.
My lord, may I submit one thing, your lord? In this case, what has happened, the issues which they have raised, they have withdrawn section 34, Later on, they have sought revival, which
Precise
has been
because-
revived, which they have not disclosed in their assembly.
I have disclosed everything,
That's it.
and that's my
That has
precise
not been
grievance, my lord,
disclosed.
that I am left
Revival.
remediless.
Revival has not been disclosed. I am carrying the order. Now, the issues which they are raising, that can be raised.
Post for final disposal. Next.
Sorry.
36.
My lord, any fix it, my lord, because
They'll give it.
they are enjoying the interim order.
They'll give it. They'll give an early date.
My lord, I'm seeking for a short accommodation.
100.
The leading counsel is hospitalized.
Attachment cancelled by housing board.
State to also file counter. State has also not filed counter.
Okay. Adjourned by 4 weeks to enable the state also to file a counter affidavit. We'll fix the date. Next. So what do you want us to do? ठीक है. Let the wakalatnama be permitted to be filed and brought on record. 37.
Yeah, please, madam. Was 37 very short, issue 2 concurrent finding of the facts of the court. Please, madam.
My lord, by a registered sale deed in my favor, which is admitted by all the parties, including
Purchased under registered sale deed.
my lord,
No sale deed.
P1, is in my favor, admitted by all the parties, even by the registrar who deposed at DW3.
No consideration.
It requires consideration.
What do you say? There's no consideration is the factual finding.
This is, my lord, may what
both
they
the
say that
matters.
there is no consideration. But the issue so far, my
that
lord,
a
may
registered
annexer
sale deed?
Yes, my lord.
Is that a registered sale deed?
There is a registered sale deed annexer P1, which was, my lord, may sought to be declared null and void on the basis that there was no consideration. And for proving this, my lord, may the document that was brought on record is annexer P2, which, my lord, may they say that it was signed by me, which I admit because he is a, my lord, may illiterate person. He knows only how to sign. And the entire recital says, my lord, may the entire thing, my lord, may everybody is agreeing that this P1 was executed. Registered sale deed executed.
What was little suspicious about the way the transaction took place?
My lord, may if your losses may kindly
That's the
see.
reason why the court thought there's much
My lord,
more.
may kindly see for a moment, my lord, may annexer P2. If assuming for a moment, my lord, may so far the law is, if there is a registered sale deed, my lord, may, and they want to declare it null and void on the basis of, my lord, may there is no consideration, then they are entitled for the money, my lord, may, and not this deed can't be cancelled. This is what has been held in the IBAN. (26/6/2006).
Not 26, 2006.
My lord.
And the
That is
suit
P1.
filed within 2 years. Not as if
My lord, may they say 26 to, this document is an admitted document. It is admitted by everybody, including registrar. Registrar says that they ask Lord May
okay, why don't you
specifically.
compromise? Why don't you settle it?
My lord, may, I have got
You
no
pay the
issues. He
consideration
came
and
to
close
me,
it.
my lord, may for the purpose he
Who is
admits
in
it.
possession of the property?
I'm in possession, my lord. He's a poor farmer, my lord, may. And he says, my lord, may, that he came to me saying that, look, there was some problem with measurement. You have to.
Findings of fact, we are not going to interfere.
My lord, may, you can.
If both of you can settle it down by
We will try, my lord.
offering something, you try and do it, both of you.
I will have instruction to that. Not an issue. Because otherwise, on the very same day, the agreement.
Okay, we have told him.
Please, madam. Please, madam.
Try and settle it, or else it's a question of fact concurrent.
My lord, may, I will try to assist your losses, my lord, may, but he came for more money, my lord, may. I have got no
You
issues in
pay
giving
more
more
money
money.
and close it.
No problem, my lord. Refer it for
By-
petition, my lord.
by 4 weeks to enable, 6 weeks to enable the parties to. Is to enter in. So just we will not say anything why an obligation. Then put it.
Simply not
To
my
enable
lord.
settlement करके छोड़ देना. 38.
Right. Was the refer to this Supreme Court Mediation Center?
We can refer it. Yes, the matter is referred to Supreme Court mediation to enable some kind of a settlement. Some kind of a settlement. The MCPP may appoint a experienced mediator.
Item 38.
May it please, Millers. Millers, I appear for the petitioner. Millers, I'm requesting 2 weeks to file rejoinder, Millers.
Why, sir?
Millers, there are certain facts, Millers, which they are placed on record by way of counter. I wish to rejoin by way of affidavit, Millers.
Okay, all right. Note kar lena, 2 weeks for the joiner. At the request of 39.
There's an item 39 we've duly served, but they've not filed any counter in this matter, Millers. We've duly served them. The other side is not appearing, Millers.
But is appeared.
No, Millers. In fact, they are moving
Shall we give
execution.
you Dasti?
Yes, Millers. I'll try and serve them.
None appears for the respondent, Dasti in addition.
Millers, interim orders to continue. Millers.
Yes, interim orders.
Please, grateful, Millers.
Item 40.
Wait, please, Millers. This is coming up after notice, Millers. A very short issue. That's whether the amount which is deposited, Millers, in terms of the arbitral award in the court, whether, Millers, the interest continues to run or does not, Millers, covered by two honorable.
There are judgments on both sides.
Exactly, Millers. So, Millers, this can be set down for hearing, Millers. I didn't want to say that.
There are
the other side is also, Millers, this may require some ironing of the crease.
Clarity on that.
Yes. Because 12 and 16.
You make a compilation of
we will. We will assist you, Lord.
Both of you.
Any
you give your compilation to him. Let them make a common compilation.
We will.
With all the additional.
One difficulty.
Money was deposited into the registry of the High Court, which accrued some interest. When the money was paid to the registry to me, this accrued interest was not disbursed.
It has to be disbursed to you.
So, can a direction, because I filed an application, but my learned friend in the High Court has opposed it, saying the matter is.
No, how can it be money which is accrued?
Correct, because that is also 2016 SEC clearly says that that is only entitlement he has.
What, that accrued interest should go?
Correct,
that doesn't mean that he can't get anything more if he succeeds.
Exactly, because that is what the Supreme Court also says. Right now, the matter on the amount deposited, whatever interest accrues.
But the principal amount was given to you.
Principal was given, the accrued interest in the
petitioner will be entitled to.
Respondent.
The respondent will be entitled to the interest that is accrued upon the money deposited by him before the.
By the petitioner before the registry.
Before the High Court.
High Court, Delhi High Court.
Upon making appropriate application, the money shall be released to the respondent.
I'm obliged.
This is without prejudice to the rights and convenience of the parties. You show this order to the High Court, get your money.
I'm most grateful.
Item 41.
A short accommodation on behalf of respondent.
There's a letter, I think.
My lord, letter.
As per the letter.
Yesterday only we filed the wakalat. 3 weeks may be granted to file the counter, my lords.
Master, note karna. The counsel, the respondent has entered appearance and seeks short time for filing a counter. Permission granted. Let counter be filed within 2 weeks.
Item 43.
Appeal for respondent.
Milords, I appear for the petitioner. I'm seeking a short passo, Milords. 43.
This is only a matter where an amendment is allowed to a counterclaim. A simple amendment allowed to a counterclaim, that too, to bring the subsequent events on record, which otherwise also.
For the respondent, Mr.
Yes.
Who is for the petitioner?
Milords, I appear for the petitioner. I'm seeking a short passo. Seniors on his legs.
After notice matter, no?
Yes, after notice matter.
Amendment of written statement.
Permitting introduction.
Pass over.
Grateful.
May I please, my lord? My lord, this is a transfer petition on the behalf of wife seeking transfer of divorce petition filed by husband from Ranchi to Patna, my lord.
1 minute. Yes. कौन सा है 40?
ये 44.
44, yes, sir.
My lord, this is a transfer petition on the behalf of wife seeking transfer of divorce petition filed by the husband from.
What do you say, sir? The daughter is with your daughter is with the mother.
With the mother. My lord, actually, may I pray your lordship to make one particular submissions that if your lordship may kindly refer this matter to the mediation of the Supreme Court, there is a very likelihood that settlement may take place.
All right.
No objection.
Mediation को refer कर लेंगे.
My lord, in case of traveling, my lord, traveling allowance may be given by the husband, my lord, because he is totally reliant.
Respondent will undertakes to reimburse the petitioner towards the traveling expenses. Next.
Oblige, my lord.
My lords, I appear for the petitioner wife.
For the respondent, my lord, if this could be sent to mediation, my lord.
You are also mediation.
Mediation.
My lords, I have no objection, but just to point out what is mentioned in the office report, I believe the wakalatnama of the respondent is still defective.
No, not of the. No, it's
Doesn't
not effective.
matter.
Just fairly pointing out.
I'll tell you, Lord. Lord, actually, I filed a vakalatnama. Lord, thereafter, another advocate on record has filed a vakalatnama. Lord, now the client is online. Lord, we have instructions to state that he's never issued a subsequent vakalatnama.
Well, I don't get into small things.
So mediation, my lords, I have no.
To the mediation.
And if my lords may also grant some traveling allowance in case some expenses to be borne. Grateful.
I'm grateful.
Lord, parties have entered into settlement. I filed the settlement. It may be disposed of in terms of.
Yes.
In terms of. Very good. Thank you.
May I please?
Lordships, I am for the first informant, caveator. I have preferred the vacation of the stay application, Lordships.
What stay have you granted?
While
Lordships,
no coercive steps, my lords have clarified on the previous.
Lordships, they have suppressed the material facts, including all court of our country, including this honorable court, Lordships.
What is the interim order which we passed in this?
Yes, Lordships.
Did we say stay of
13-10-2025?
It is simply.
Simpliciter, no coercive steps. That's it. My lords, it's 13-10-2023. I can pass.
Does the FIR contain only land grabbing?
Lordships, including
any other offense?
Other offenses under IPC, Lordships, I have preferred an application.
So if there are other offenses, there is no stay.
Lordships.
Other, we'll clarify that.
Lordships, I have in my application, page number 87, Lordships.
Can't take undue advantage of it. There are cases in which FIR is filed on the basis of land grabbing court solitary. In such cases, we are granting interim orders, not to stay of all criminal cases.
What my friend is not saying, I'm
Lordships,
acquitted in all those FIRs.
Lordships,
we are not.
Yeah, that is not before my lord.
My submission.
Where is your FIR?
My lords, my paper book, my lords, annexure P2, my lords.
Page number.
We are page 33 of my
47 or 47.1?
47.1, my lords. That's the lead matter. 47 is the lead matter. That has no bearing with.
Your application for vacation is filed in 47 or 47?
47.1, Lordships. I have also filed the written submission, Lordships. Earlier occasion, my lord is permitted to file the written submission.
My lords, I'll just clarify. I'll just clarify this. My lords has appointed.
The FIR, please.
My lords, page 33, my lords, of the paper book. Annexure P2.
IPC offenses are there.
Version of the FIR is the wrong, Lordships. On page number 34, paragraph A and B is wrong translation, Lordships. B, village Bhola, Taluko Dhoraji, district Rajkot, rural.
Substantially.
It is mentioned false.
What are the other criminal cases pending?
My lords, 323, 323, 323, 302, all acquitted, my lords. They are not stating that. Secondly, my lords, when my lords passed this order giving no coercive, they were there on caveat where they pressed. On the previous occasion also they pressed. So there is nothing to do with
Lordships,
grabbing.
they have made the forgery with the government record, Lordships. Made the forgery with the government records, Lordships, and made the Akarani Patrak. Yes, Lordships.
Day of criminal proceedings here.
My lords, 13-10-2026. If my lords want, I can pass on the hard copy. I am carrying that on.
Disposal of investigation is not stayed. It's a problem, man. Post along with that batch. Nothing more.
Yes, but it is already posted. My lord.
Posted along with the batch.
Lordships,
It will come with the main case.
clarify that Lordship's clarification is required. Investigation officer will do the investigation under IPC section, Lordships. And one petitioner is arrested, Lordships.
Continuation of our order dated 31/10/2025.
13, my lord.
13/10/25, it is clarified that the direction not to take coercive action is relatable only to offences under the Land Grabbing Act. पूरा act दे देना. Offences under the Gujarat. क्या नाम है उसका?
Gujarat land grab.
Post this along with the batch of matter.
And Lordships, one thing is that petition number two was arrested, and suppressing the material facts, they have obtained the stay, not disclosure before this honorable apex court, and stay is not in operation to the petition number 2. Lordships, clarify that.
All right.
Next.
My erstwhile advocate has sued me for professional fees amounting to 12 crore 50 lakhs.
My lords, I'm requesting for a passover.
Passover.
My counsel is.
All right, Passover.
Great.
I'm appearing for the respondents. We'll file, well, it's in 4 weeks, we'll file the compliance affidavit.
Respondent number 1 was not served if she's appearing for all the respondents.
That affidavit of compliance will be filed in a week's
4
time.
weeks' time.
4 weeks' time. Permission granted.
Great.
Next.
Item 50.
Yes.
My lord, in this matter, the office report has been submitted, where it has been said,
Click and withdraw the. What happens? Why is this coming? You withdraw the money is what we have said last time also. This is the last order
that
copy.
is the document showing a different name. There is a spelling mistake from the beginning, my lord. From the inception of this litigation, the
What do you
name is
want?
different.
What do you want?
So, let the money.
You already passed an order. You already passed the order.
Let it be released on the document what I have submitted, the account number I have submitted.
Some discrepancy in the leave. So
On the name only.
On whose amount is,
Amount.
This court has to release the amount,
Please.
right? Upon production of sufficient proof and after verification of the correct name, the amount may be released.
Please.
Give them the upon. Bring the office report. Produce the office report.
Rishabh and Rishabh.
Correct name properly, the proof of your correct name.
From the inception, my lord, it is coming incorrectly, my lord. The last 14 years, it is showing the Rishabh, RISH.
Exposed in the name. Master Rishabh Sharma, right?
And the correct name is Rishabh, RESHAV. All the documents are reflecting this RESHAV.
That's your client.
Yeah,
That is your client. Ask him to come and then show his proof and then withdraw the money.
Yeah, we'll show the proof, my lord. All the documents will show the proof.
Then go in assistant registrar. Upon
And my lord, there is one
master research.
One more difficulty.
So peruse the office report dated so and so. Upon the petitioner, upon the Master Rishabh Sharma appearing and producing necessary documents evidencing his correct name and address, the registrar judicial may release the amount after due verification. What else is the other problem?
My lord, actually, he is 100% blind. So he is incapable of doing any transaction. So I want his mother may kindly be appointed on his behalf to do all the transactions.
We are informed that Master Rishabh Sharma has visual disability. He may be permitted to be accompanied by his mother to assist him.
Obliged.
He can be permitted. Next.
May I please? No, the concurrent findings of the courts below has been set aside by the High Court while exercising the power under 100 million. That apart, for want of jurisdiction, the order is a nullity. Now, the civil court has no jurisdiction to deal with these matters. This relates to only revenue divisional officer who is a revenue court under the Act. He alone is competent to so. So, his order is a nullity for want of jurisdiction. That apart, the High Court has
350 days delay.
What?
355 days delay.
No, it's not here.
Item 51, right?
Huh? 51.
Huh. Indra Ramakrishna.
No, my lord. Actually, there is a delay of 14 days in only refiling.
All right, doesn't matter.
No, this is Indra Ramakrishna. So the last date.
And living in different.
I will explain. I will
Yes.
explain. No, the order was passed on, you ask me, see page 1. It's passed on 7/1/25, my lord. The certified copy or
No, doesn't matter. You can tell us on the merit. Doesn't matter. We will condone the delay. Don't worry. Tell us the merit. Defendant number 1. That's the old lady.
The 7/1/25.
She cannot contribute her
That
personal evidence.
jurisdiction is not there. It's
What
a serious
jurisdiction?
error, madam. May I
How much
take-
time you want to vacate? You tell us. We will give you.
Madam?
We'll give you some time to vacate.
No, madam,
How much time you want?
This matter, madam.
From 60 you are there.
there is
1990
no
onwards, the matter has been dragging on. How much time you want? Tell us.
May I say, madam, this will be great injustice.
Why?
Madam, I'm sorry, madam. May I point out the relevant section, madam? Civil court has no jurisdiction at all. So that's why respectfully initially submitted is an order without jurisdiction.
Perumal, you are in the second appeal also. All those were considered by all the 3 courts.
Not,
High Court has second appeal.
no, madam, it's a concurrent finding which has been reversed by the High Court.
The bar under section 6 will apply provided you are able to prove that you are a personal tenant. That evidence you have not led. All of you are appellant number, petitioner number 1 is an old, 1 minute. Listen, appellant petitioner number 1 is an old lady. All the other petitioners are full-time employees and they are living in different cities. So they are not in personal cultivation. Therefore, bar under section 6, that is the finding does not apply.
No, what I will
So
say.
you, the burden,
in response-
if you take a plea, the burden is on you to prove, right?
No,
So
I am
the
disputing
burden
that.
was on you to prove that you were in personal cultivation. There is no evidence.
The act requirement is if it's a joint family, one member is sufficient. Here admittedly, the son who stays there, he is looking after them.
Nobody is
But
there.
the others are, one is elder mother and others are 3 sisters married and went out. They are residing nearby.
Declaring on
Which is
Perumal.
Coimbatore, madam. Which
See,
is
what
only.
we are, the finding against you is that is why we are sympathetic. We can grant you some time because the defendant number 1 is
Is 80
very, very
80
old,
years
aged,
right now.
can't contribute. Defendant number 2 and 4, her children are not even there in the village.
No.
And D5 is electrical
mother
contractor, no proof
Only
that they are
subject
continuing.
respondent are residing there, madam.
Then in which
Actually,
case,
she is aged, 85 years. I accept.
how much time you want?
It's at least 2 years, madam. So
2 years.
For more than 6, the crops are there
We
already.
will issue notice, the issue notice confined to the question of granting some time, suitable time for the petitioners to vacate the premises. Right, we'll let them come, we'll consider them in the grant. Next.
Madam, in the meantime, let them not execute. Madam, they are gone for execution. Madam. In the meantime, let them not proceed with the execution. I'm all.
Limited notice, or else you would have.
Yeah?
Limited notice.
Yeah, I got it. I'm obliged.
I'm sorry, yesterday I was not there. Yesterday was my legs.
This has come from yesterday.
Item.
Item 52, that charge sheet, my lord, which the
We
tribunal
have
had
gone through
quashed.
the judgment, Mr. Patwalia.
Yes, my lord.
To stay the disciplinary proceedings is difficult.
My lord, just kindly see, we have made this chart.
Yes.
There is something very, very extremely serious. First of all, there is no charge made out in the charge sheet at all. There is absolutely no charge made out in
Mr.
the charge.
Patwalia, we were
Yes.
just, because after our last, we again gone through yesterday. These proceedings is not overnight it have started. It had occurred earlier also.
No, but Lord,
And
I'll tell you, Lord,
much before.
I'll tell you, Lordship, how
It's not, we had a little suspicion last time that it was intended to corner you, but then it is not. So,
yes, because I'll tell you, Lordship.
FIR is of May 2023.
No, FIR is independently proceeding. This FIR has nothing to do with this. FIR I have challenged in the writ petition in the Bombay High Court in May 23. On 7th June 2023, please note these few dates. On 7th June 2023, I file a rejoinder in that FIR. Now, after my rejoinder is filed, that my criminal writ is argued, it is admitted, and further proceedings in that criminal writ are stayed. That is the end of the matter. Then, my lord, what they do, on 18th March 24, after about a year, just give this chart. Have you given to Mr. Raj? Just have this chart for a minute. I have gone through, I have prepared it for your lordship's benefit, my lord. I have not prepared, my lord. Mr. Prabhas has prepared it. He's done a good job, my lord. Now, kindly see this.
You should prepare. You should do all this before the disciplinary proceedings, not before us.
No, but just, it's completely malafide. Now, kindly see these 4-5 dates, and I'll just read 2 pages of the CAT order. That's all. 18th March, they keep my name in a sealed cover to deny me promotion. That is the first date. On 17 December, the CAT allows my claim, says you promote him. Now, they don't challenge that order. They don't obey that order. I file a contempt. On 15 July 25, in the contempt, presence of the chairman is called for. After the presence of the chairman is called for on 15th, on 21st July, they immediately file a writ against that order of the CAT, which says promote. That writ is heard. Orders are reserved on 29 July 2025. The High Court repeatedly says, if there is no charge sheet, if the High Court repeatedly says, if there is no charge sheet, how can you not promote him? Now, what they do on 25th and reserves the order.
Still incomplete. There are some letters.
Just, Mr. Raju, let me make something out
What
of
you are
the
saying
complete
is
list. Then you
exactly
complete it after that.
Para 4 and para 5 of the High Court judgments are all these.
Now, my lord, on 11th August, what they do, please have page 457 with me. I just want to read this page. Please have page 457 with me. Kindly. This one page, 457, CAT order. Please have this. CAT examines the High Court, my lord, on the very first date of hearing has rejected the petition. On the first date comes up, it is listed for mentioning. On mentioning, the court says come at 12. We go at 12. With great difficulty, we say give us 1 week and the matter is over. CAT examines it threadbare. Now kindly have para 6.26 and 6.27. 2 paras here with me. Learned counsel argued, this impugned charge memorandum clearly demonstrates the malafide intention of the respondent in proceeding against the applicant, reflects their contemptuous behavior, inasmuch they have deliberately chosen to defy and frustrate interim protection. That I'll come to later. But just see the next para now. Learned counsel submitted that CVC advice, 11th August is the charge sheet. Please read this para. Dated 11th August in respect of the departmental proceedings against the applicant was on the same day mechanically and hurriedly forwarded for further action. The forwarding order itself conspicuously bears the endorsement urgent out today, which demonstrates that the respondents were acting under a preconceived determination to inflict punishment upon the applicant. Such extraordinary haste in circulating the CVC advice on the very day of its receipt is a classic instance of predetermination and non-application of the mind. Respondents, instead of objectively considering the matter, have shown overzealous alacrity that is incomparable with settled principles of fairness. Then 4-5 lines later, the undue and unwarranted urgency displayed in this case leaves no manner of doubt that respondents are hell-bent upon penalizing the applicant.
A little too much, huh?
Now, further, my lord.
We don't approve of all this kind of an overstretch with the tribunal at a stage like this.
Completely
uncalled for.
My lord,
Completely uncalled for. And then come back to your list of dates.
Yes. Now, kindly have. Now the orders are reserved, my lord, on 29th July. On 11th August, this charge sheet is given, and I'm going to read the charge sheet. There is no charge made out in this charge sheet, my lord. Before I go further, please read the charge sheet with me. Just kindly have page 72.
I could have extracted.
No, just have from page 72, my lord. High Court has
74 it is extracted.
Yes, 74 page. Just have it 74.
All right.
Please have 74.
Yes.
Shri Samir Wankhede.
Yes, Mr.
Your lordship got 74.
It's there in page 2.
All right.
Despite having been
yes, despite having been no, but not the details are given. There are 2 memos, operation of which was stayed by the tribunal, and
read it. Despite having formally been
yes, Shri Shamir Wankhede, despite having been formally detached from the Narcotic Control Bureau on 2nd January, and hence no mandate relating to investigation of the case, willfully and deliberately sought sensitive information from Japan Babu, the then legal advisor, on 2nd June 22. Charge sheet has been given in 25, 3 years later, as evidence in the telephonic transcript filed by the officer before the High Court on 7 June 23. This transcript is filed 2.5 years earlier, and High Court, after reading this transcript, admits the petition and grants me an interim protection. This is the first charge. That and what has happened? They wanted to exclude one particular boy from the entire investigation. Now that is the FIR against me. That is this charge sheet. Now please have the second charge. That Shri Samir Wankhede obtained an assurance from the DLA to steer the investigation towards a predetermined outcome. The extract of the transcript reveals that DLA refers to a prior promise which suggests some assurance. There is no charge made out against me, my lord. This is only to deny me further promotion and to victimize. Now, my lord, the proof of the pudding is in its eating. My lord, so therefore, the first charge is I have filed a rejoinder on the.
Explain all that, Mr.
My lord,
is it a what short circuiting all this?
No, my lord, I am saying there is no charge made out against me.
At least our conscience says it is not as if it's such an absolute clean slate where there is nothing at all. I mean, we have no hesitation in interfering. When our conscience in Article 136 feels that it is not a situation where we need to interfere and then quash the entire thing, we will give you that kind of a protection that you need.
But
so far as the disciplinary proceedings are concerned, for an expeditious conclusion.
No, just let me tell your lordship that also. But now please have the High Court order. Please have the High Court order.
Not as if it's not.
No, just, my lord, they are hell-bent on dismissing or doing something drastic.
It is not as if you are such an innocent person.
My lord, please see my record.
At every stage and every corner and every second you have gone to the courts.
No, but please see my record.
And stalled it. Look at it. I mean, it's not as if that you need some kind of an additional overprotection as if you are such a vulnerable person.
Lord,
which court you have not moved, which tribunal you
Lord, I have succeeded everywhere. I have succeeded everywhere. Wherever I have gone, I have succeeded except for this one order.
You are forcing us to say.
That is showing victimization rather.
You are forcing us to say things which we don't want to.
Lord, may I?
Leave it at that.
Just let me read 2 paragraphs and make one more point, then your lordship may see. Now kindly see the High Court order now at page 28 first with me. The High Court order at page at para 28.
That you should show.
Please see the High Court order para 28.
Anything which is troubling you, you tell us. You will try and protect you.
No, I am going to show their malice. I am going to show their malice from this. Just read, see this.
20.
Para 28, page 13. Undisputedly, on 15th April 25, the tribunal only directed the personal presence of the respondent shall not be insisted upon. However, pursuant to letters dated 2nd April so-and-so, there was no order passed restraining the department. From a reading of the order, it appears tribunal has tried to prejudge the issue without realizing that tribunal or court should and is expected to exercise self-restraint while so-and-so. Interfering by the court at the stage of issuance of articles of charge is restricted in rare circumstances. At this stage, when even inquiry officer was not appointed, only explanation was sought from the respondent regarding the charges. Interference is premature. Now have para 31. Last 3 lines. In case the explanation furnished by the respondent is found satisfactory, the competent authority may proceed to appoint, is found unsatisfactory. The competent authority may proceed to appoint the inquiry officer and inquire into the matter. Now the High Court says it is premature. They have asked for your response. You file a reply. In case they find it unsatisfactory, they will appoint an inquiry officer. The moment the High Court dismisses the writ petition on 7th March, without waiting for my reply, they have appointed an inquiry officer and a presenting officer. They are hell-bent on coming against me, my lord. The High Court has rejected my claim on the ground that this is a show cause notice. You will file a reply. They will examine the reply and then they will
have gone against the charge memo, right?
Yes, my lord.
Okay, give us the facts after the charge memo. Immediately after the charge memo, you went to the court. Nothing.
My lord, the charge memo is dated
was on 18th of August.
18th August 2025.
Did you filed this petition on 26th
I
of August?
filed the petition, my lord, after 18th.
Then everything got stalled.
And 27th August.
CAT allowed it on 19th of January 96.
CAT allowed it, no, CAT allowed it
19th January.
19 January 96.
Correct.
Yes, 19 January.
Mr. Patpalia, we are not interfering.
My lord,
while we are not inclined to interfere.
The point is, my lord,
you want this, we can direct that it should be disposed of expeditiously and close it. Because
your lordship may not say that because
we don't want this to drag on for years together.
Lord, the moment your lordship says that, I will be dismissed from service. Your lordship will take it. I don't want your lordship to say that. Okay. What I do want your lordship to say is that after the High Court, without waiting for my reply, they have appointed an inquiry officer and presenting officer. What kind of an opportunity is this?
Yes.
Sufficient time.
No, my lord, there was a stay. High Court had quashed it.
Tell us about
Just kindly see this.
Tell us those dates.
Now, my lord, on 27th August 25, the CAT was pleased to stay further proceedings in the charge sheet.
August 20.
Yes.
1 minute.
On the right hand side, second date. 27th August 25, yes, CAT was pleased to stay further proceedings in the charge sheet.
Then CAT order came.
Then CAT on 19 January quashed the proceedings.
Correct.
The High Court on 27th February 26 reversed that order.
Correct.
I filed the SLP.
Order. That's right.
I filed the SLP on 2nd March itself.
Correct.
On 7th March and 10th March, they have appointed an inquiry officer and presenting officer. I have not even filed a reply to the charge sheet. My lord, and kindly see what the High Court says, my lord. It's a High Court relies on Evidence Act to oust me.
We will say that.
Your High Court says, how will Evidence Act apply?
That portion of the High Court.
Just see page 16. Now, this judgment, if it stays, no charge sheet, and my lord, the other thing. Just kindly have, my lord, this actually needs your lordship's interference in a slightly more detailed way. Just kindly see the charge sheet with me for 1 minute, kindly. Just see 2 pages of the charge sheet. Kindly see page 82. Kindly see page 80 of the charge sheet. The 2 charges.
Corruption matter, Mr.
Oh, it's not corruption. It's not at all a corruption matter. There is no question of it. That
it's not as if
it's a matter.
Page you want us to see?
Page 82. They are relying on no document, no witness. How are they going to prove this?
So wherever there is no, so you will quash every cases like this.
No, my lord.
What are you saying, Mr.
What I am saying is there is no charge made out. There is no case made out against me, my lord. Just kindly see page 82.
The cart before the horse. Then to say that there is nothing, so therefore don't even inquire against me.
My lord, inquiries. A person goes and files a rejoinder.
Want us to see?
Yes. Please see the list of documents by which the article, page 82, annexure 3.
Based on its transcript, admitted transcript by the petitioner.
a matter like this. That doesn't mean that every case we just.
No, your
80?
page 82.
Anyway, what is the observation that you are suggesting?
No, just kindly see page, my lord, what I am suggesting
What
is,
is the
this needs to be quashed, this charge sheet, my lord, is what I am suggesting.
No.
Now, page 82, kindly see page 82. List of documents by which the articles of charge framed are proposed to be sustained. Your lordship has got that line in the middle of the page. Criminal writ number so and so filed by Shri Wankhede, copy of the affidavit filed by Wankhede, that is the document. Now, क्या चीज? But just could you allow
Mr. Raju?
Yes, madam.
This aspect of it is indicative that you have not waited and proceeded further.
No, we have waited.
To appoint an inquiry. Just answer this question.
No, I'll tell my lord.
Give us the dates and then tell us what you have done.
My lord, kindly have a look at the charge memo was restored by the High Court on 27th February 26. 27th February 26.
Yes.
Now kindly have a look at Rule 14, my lord.
Rule 14.
Yes.
So what does it say? It need
It
not.
is extracted in the petition.
But then there is an observation of the High Court, right? That he should be given.
Page 15, we are given. Kindly have a look at that, my lord.
So what do you say about the High Court's order?
Regarding time has been given, my lord. 27th onwards, he had
will be
15
heard,
days
right?
time. He did not do anything within 15 days. Therefore, we are entitled to appoint an inquiry officer because 15 days window was given to him.
Which
Kindly have a
15?
look.
From
The officer was-
27th February to 7th of March is 8 days. Which 15? My friend is talking of.
27th and 27th February and 7th of March. And then the stay was only, my lord, from 20th August to 27th August, there was no stay. There were 7 days there, my lord. Kindly have a look at the dates. But the charge memorandum was issued on 18th August 25. It was acknowledged by him on 20th of August. Therefore, 15 days time starts clicking from 20th August. There was a stay, my lord, on 27th, so 7 days. Therefore, we did not do.
We will only say that the appointment of an inquiry officer done on 7th March 2022. 2026 will be done after giving him an opportunity.
Inquiry officer
To
and
respond.
presenting officer both, they go together.
Just do that. Or else, it gives an impression that
this-
everything is being wrapped up.
This is enough for me, for notice to be issued, my lord. My learned friend is justifying that you are appointing inquiry officer without opportunity.
The Patwalia. Wherever there is an error, we set aside. That doesn't mean you are endeavor, we can understand. Cut it from the very beginning so that nothing else will remain.
Lord, what is
Because
this?
we are not
Lord,
satisfied to
in
the
my 40 years, I have never seen a charge sheet like this, my lord. That I have filed, a person files a rejoinder and a person files a rejoinder and he is being proceeded against. And my lord, may I give me one more indulgence? Kindly allow me to show 2 more pages.
Seven 2026 is without giving due opportunity to the petitioner. For this reason.
My lords,
while
will not
we-
say you because the opportunity has been given to him.
No.
I'll demonstrate how it has been.
Sufficient opportunity. The petitioner will be given, we permit the petitioner to represent, he can represent and represent within.
File a reply to the charge.
File a reply to the charge sheet within 1 week. Within 1 week from today. And the said decision will be taken, and thereafter the decision will be taken by the respondent within a week thereafter. You'll say 2 weeks instead of 1 week. 2 weeks from today, and the decision will be taken 2 weeks thereafter. Decision to appoint the presiding,
2 weeks.
the inquiry officer. Decision to appoint or not to appoint the inquiry officer and the presiding officer 2 weeks thereafter. found. They have not expressed any opinion on the merits of the matter. With these observations, especially.
That para 42 and 34 of the High Court, your lordship may look into those. I mean, the para 34 High Court says Evidence Act applies.
Otherwise, I can demonstrate that even
It's not such
the
a-
officers were appointed within time, my lord.
It is not so innocent a case, so.
And 42, he says.
Force us to say more.
All right. Otherwise, my lord, the observations are far too sweeping. That inquiry officer is not supposed to.
Your tribunal was totally unjustified in interfering.
My lord, actually, I'll tell your lordships, my lord, on that. Tribunal has been seeing everything unfold before it. Now your lordship has passed the order.
Leave it at that.
Otherwise, 3rd April, when they called me for a hearing, tribunal stayed it. And Lord,
There's a lot to be said about the tribunal, my lord. I will also say if the need. Grateful.
This was not necessary. It's a former Chief Justice who's heading it. And secondly, my lord, this is obviously there's much more than there is.
So
this is
therefore
like an iceberg. What your lordship
can't-
sees
you
is
can't
only
cut-
1/10 of what the real reason is.
There is much more than what.
Yes.
Either side.
Anyway.
Either side. Yes.
Request your honors for a short passover.
Also,
Yeah, the leading counsel, Mr. Niranjan Paul, is in another court.
Lords, in fact, these matters are very similar to what your lordship
Which item?
decided yesterday,
Which item?
Lords. Well, it's actually 53.
I'm requesting for a short passover, Your Honor. The leading counsel is another.
Okay.
At the moment.
No more, sir. We have dismissed yesterday similar matter. Dismissed. This is dismissed.
Wait.
Next.
Yeah.
54.
Lordship, he was requesting for a passover. Mr. Paul is actually.
Yes,
I only-
identical orders, you are aware of it.
It's not identical at all. Yesterday's matter was a matter wherein they had actually sought lowering of the percentile. But in our case, it is not so. In this particular case, the relief itself says.
Veena, the date has passed. You have seen that we have not.
Lordship, no, here, Lordship may just take a note. At page 12, we are only seeking an extension of a week. Students are very much available who are qualified.
Same point.
No, Lordship, there they had actually specifically, I have seen the relief part of it, Lordship. Yesterday's matter was different. In that matter, they asked for lowering of the percentile.
No, you are not aware.
They're not.
You are not aware. You are not aware, she knows. Okay, Veena.
No, they were not
No.
asking for an extra round of counseling.
Extra round of counsel.
That was not asking. for
Already done
reduction
that.
of
Curtains are
percentile.
closed, Veena. Thank you. Dismissed.
Yesterday's order is very much there with me that says that representation to the government of India and the representation.
You want to make a representation, you make a representation.
That is the order passed yesterday's matter. Lord.
That's only a representation. You want to make a representation. Go ahead, same order. Next.
In, I think, 54. Your lordship. Go ahead.
Petitioners are
What is this, Mr. Bhushan?
poor people who had made their dwelling houses on what is called Porambok land, village common land. Now, they've been residing there for many years. There are many thousands. In fact, my lord, there is a Indian Statistical Institute campus there